Welcome back. As you know, I'm your host, Linda Kenny Bodden. This is For the Record, and we are the Law and Crime Network. And we're covering a trial this week, last week, and probably for the next several weeks out of Minnesota. And you know it well. It involves the shooting and killing of Daunte Wright. He was 20 years old when he was shot and killed by Officer Kim Potter, who drew her service weapon instead of her taser, even though she yelled, "I'm going to tase you, I'm going to tase you," and then taser, taser, taser. It happened on April 11th during the pendency of the Derek Chauvin trial for the killing of George Floyd. Well, we have been immersed in various things that have occurred at the scene to determine, and testimonies to determine whether or not she could be convicted by this jury of first or second degree manslaughter and serve up to 15 years in prison and maybe more if there's aggravating factors. But one of the testimonial witnesses was a Sergeant Michael Peterson. He was on the stand yesterday, presented first by the prosecutor, Matthew Frank, and he's going to talk about the use of force and the training in that specific Brooklyn Center Department. Okay, let's discuss this. Yeah, Lisa Lockwood, I mean, if you take the direction that this seems to be going in, that the prosecutor actually seems to be responding to what he anticipates are the defense arguments, anytime you stop somebody and they possibly resist, even if it's a mild resistant or a passive resistant, you could be able to shoot them if you perceive them to be a threat. That can't be the law, is it?
No, it's not the law. It's not the law. It's based on the use of force continuum. Somebody is about to be put under arrest. They have an active warrant, a felony warrant, a gun charge, and they're resisting, and they are attempting to flee. All of those things are there. They are clear. Did she have the right to use a taser? 100%. I think that was proven with all the experts that we've already seen. This was a mistaken identity for her service weapon and the taser. So bringing that forward, saying, did she have a right to use a taser? Yes, 100%. Now adding to the mix of, did she have the right to use deadly force after the hindsight of perspective based on body cams and the other officer who was halfway through the window? If that was the case, the officer who was halfway through the window could have used deadly force as this person was attempting to flee, because he could have injured himself and caused death to himself based on the actions of the driver pulling away. So he didn't do that. He de-escalated and got out of the vehicle. So, you know, deadly force was not necessary in that moment.
Yeah, and no other officer even pulled their service weapon that I saw, but maybe I missed it. Yeah, Lisa Lockwood, he actually did a demonstration in court, which we'll talk about after, including the spark test here. But the more the jury sees that taser and this officer handling that, as we just saw in that little clip there that was playing when Judge Rucker was finishing up, they're going to understand that that's a taser, and they're going to be able to see the difference between a taser and a firearm. Is there other differences besides the color, which was one was yellow or partially yellow and one was black?
Yes, there are many differences. The texture of it, the weight of it, the weight is completely different. We also have the grip is different. So all of that is definitely different. But I think what is important is educating the jury on the use and the training of what police officers do. And I think it's also important for them to understand what muscle memory is and how an officer reacts, the adrenaline, the tunnel vision of what happens in a situation where they are focused on the safety of the people around him, go ahead and making sure that the arrest happens, and all of those factors that are involved. So again, like I said, he had an arrest warrant, he was resisting, she had a rookie in front of her, and maybe the excitement of all of that, she felt that she needed to be in that position to go ahead and take her taser out.
Yeah,
and again, it was mistaken.
It was mistaken. Lisa Lockwood, the defense had made the argument that in some areas of policy it says shall, and legally shall means you must do it. But in other areas, such as the spark test, it said should, and legally that doesn't mean you necessarily have to do it. Was that a good argument to make, or did Matthew Frank on redirect just like wipe away that argument when he asked the officer, why does it say shall? What's a circumstance that you wouldn't be able to do this spark test on the taser?
Right. So what's the implication? The implication is that maybe she wasn't such a great officer because she didn't do this spark test. To become a field training officer, you are considered the highest of caliber on the police department. You have the ability to train a brand new officer to do the job that you've been doing. You've got experience. You've done a great job. You don't have a tarnished record. So at the very minimum, yes. Should she have done that? Absolutely, as part of policy, just like all the other pre-tests and safety tests that you do to get ready for your shift, checking your vehicle, making sure your lights and sirens work, making sure you have your extra artillery, you have a shotgun, making sure that that's loaded. There's one in the chamber, making sure your radar is working and calibrated. So there's a whole process, and she would know all of that needs to happen, especially with a trainee. So what it's doing, it's poking holes into her character. Maybe she wasn't the best officer because she didn't do that calibration, that spark test.
Yeah, so interesting.
And your question about the scenario for this is?
Should that individual be stopped?
Yes.
Okay, Lisa Lockwood, again, you are the only one of the three of us. Like the jury, though, Judge Rucker and I have not been a police officer. You have been. That redirect with the officer, Peterson, asking the defense attorney more questions, more questions, more questions. Why was he doing that, and what was the ultimate effect?
I think it was just to show the imminent danger that was there. Would a reasonable officer believe that they were in danger if Daunte did drive off, and would that officer be dragged, hurt, injured, hit with the door, et cetera? Would it be okay to use a taser? And I think we already know that it was okay. We know that from multiple expert witnesses who we've had on the panel already, who have been in the box. So I think that was it. Just, is that a reasonable use of the taser in the use of force continuum? And the answer is yes.
Commander, I apologize for mispronouncing your name. It's Gary Phelan. The S is silent. Lisa Lockwood, taser seems to set, we discovered yesterday, a lot of the policies. I mean, the police officers, the police departments just co-opt their handbooks or the handbooks of some other third party that comes in and says, let me set your policies. When you were a police officer with the SWAT, did you also carry tasers? And could you tell me what the reaction, why you have a dominant and a reaction side for them?
Yes, I did not carry a taser. They weren't implemented when I was on the police force. But knowing that muscle memory and what is tied to it when you're pulling a weapon, your dominant side, your reaction side is whether you're right-handed or left-handed. So it's going to be based on that for the particular officer. Having a cross draw and mandating and having a policy to put it on the opposite side is supposed to interrupt the muscle memory, so you know you don't have a deadly weapon and it's not a deadly weapon scenario for the use of force. So the whole idea is to put it on your weak side, less dominant side, for you to interrupt that pattern. And that's the sole purpose for doing that in all training. When I was on SWAT, I had two weapons on my right side, one on my hip and one tied to my leg, an MP5. So that was deadly force. I knew it was there, it was ready, it was accessible, and I used it as needed. So that's why it was completely different. The way it's carried, as far as a cross draw front or using your weak hand to pull it out and then putting it into both of your hands, is up to the discretion of the officer and their comfort.
Lisa Lockwood, I've handled civil cases where the police have shot into a car, killing the driver, and there'd be an innocent person. In one case, I can remember a woman on the passenger side. Now, you don't want to shoot into that car because you don't know whether that person is a culprit or just an innocent person. It has nothing to do with it because you don't want to kill the passenger, correct?
You're exactly right. You have to know what your backdrop is. Why would you want to fire upon somebody with the potential of hurting somebody else and get an innocent victim? Even if that person was wanted for murder, even if that person had a gun, if they were firing out the window and you've got an innocent person in that vehicle, you don't have the backdrop, you can kill that person and anybody else, any bystanders along the way. It's extremely dangerous. And, that's why officers have taken to ramming cars and that sort of thing and not actually firing into a vehicle, because of the precedent that was set so many years ago of police officers firing on vehicles and injuring, hurting, and killing people and innocent bystanders. It needed to happen.
And that's why there's so much attention being paid nationwide. And in this trial, even though you may get a little bored, on the use of force and the policies relating to the use of force and the practices and the execution of those policies. We're going to take a quick break here at the Law and Crime Network. When we come back, we'll check and I'll let you know whether or not the jury in the Kim Potter case is back from their lunch hour and whether we'll be going live or we'll bring you some more updates. Stay with us.